Yes.
Was the reference to Clark and Linsell is paragraph 28-26 of the latest edition, which deals with abatement as a form of self-help. I was just completing the list of protean characteristics of nuisance. The next one was the fact that natural hazards and nuisance through man-made operations or artificial structures are dealt with slightly differently. Certainly historically, of course, the natural hazards were completely different. There's also a certain difficulty with the terminology, as the recent case of Jalla pointed out from Sedley Denfield, the concept of what is a nuisance and what is really a nuisance in waiting. In Sedley Denfield, the grating was badly placed and liable to cause a flood. It wasn't actually a nuisance as it then was, but that was the nuisance. So whether that's a continuing nuisance or a continuing nuisance in waiting or what is a complication. And of course, when one's looking at a continuing nuisance, it is often important to realize what the significance of that is. For instance, is it limitation of action, as in the recent case of Jalla, or is it something which is simply saying that rather than have to identify 1,000 causes of action, you call it a continuing nuisance, but it is 1,000 causes of action which accrue each day. And similarly, in relation to, as we'll see in Delaware, a continuing nuisance may be important in relation to an abatement, particularly, or an injunction, particularly where there's been a one-off event, but you want to have an injunction or abatement to prevent something being repeated. So if I could just take your lordships to Jalla, which was a recent decision of the Supreme Court. It's in the authorities bundle, and if I could just, probably convenient to have a quick look at Mr. Justice Stuart Smith's summary at MS 609. Where he says at paragraph 64, there's no doubt that a nuisance can be continuing, one such that every fresh continuance may give rise to a fresh cause of action. A classic example is Battershaw and Reed, where the defendant built an erection higher than the plaintiffs, and having removed tiles from the plaintiff's eaves, had placed his own eaves so as to overhang the plaintiff's premises. This nuisance was held to continue from day to day. At the bottom of the paragraph, as Lord Atkin pointed out in Sedley Denfield, there's a risk of imprecise language in referring to a state of affairs that has a potential to cause damage, as itself being a nuisance. What is clear is that the cause of action in nuisance is dependent upon the occurrence of damage. And then if we go to the Supreme Court's consideration in Jalla at MS 623, my Lord Burroughs says at paragraph 23, in Delaware mansions, the roots of a plane tree had caused cracks, which appeared in 1989. The land on which the block was built was then owned by the church commissioners, but in 1990 they transferred the freehold to Flexan for £1. The defendant highway authority refused to remove the tree. The claimant Flexan carried out the necessary underpinning works to protect its property at a cost of $570,000 and claimed that cost from the defendant. It was held by the House of Lords they were entitled to the damages. There was a continuing nuisance of which the defendant knew or ought to have known, and reasonable remedial expenditure was recoverable by the owner who had to incur it. Now, that in certainly where I work is often misunderstood to be thought to mean that although the damage occurred in the period before ownership by FlexSun, they were entitled to rely on this concept of continuing nuisance to backdate the damage to, or to forward date, I suppose, the damage from their ownership to the original cracking. But that, in my respectful submission, wasn't the case, and it may be from comments from my Lord Stevens that I'm actually preaching to the converted when I say that Delaware Mansions was not a case in which damage to a structure had given rise to a cost of repair, which was then awarded, because underpinning doesn't repair cracks to superstructure. What underpinning does, it doesn't jack up the building to bring it back to its former position. Underpinning is merely a method for replacing what has been lost, namely the soil which no longer supports the building because of the actions of the tree root.
It would be very odd otherwise, because it would be odd if you could purchase a property which was in a state of disrepair at a price which reflected the fact that it was in a state of disrepair, and then recover the repairing it.
Yes, it would, although I can see there could be a difficulty if you did do that. You would still have a claim to say, well, for the future, there is this nuisance, not causing any damage at the moment, because it caused the damage last year. But in order to stop that for the future, you must either cut down your tree or I must put in underpinning.
Yes.
So just to make that plea good, I would like to commend to you, if not actually take you to, the decision in the Court of Appeal in Delaware, which is in Divider 2, Lord Justice Pill.
Page
410.
Thank you.
It's at 411, the holding, as the nuisance was a continuing nuisance, the fact it had commenced prior to the second claimant's acquisition did not defeat the claim. Where there is a continuing nuisance, the owner is entitled to a declaration to abate the nuisance. Damages for physical injury and an injunction, in principle, is also entitled to the reasonable cost of abating the nuisance. And 2, the nuisance existed during the second claimant's ownership of the land. Accordingly, the relevant damage was the cost of the necessary and reasonable remedial work. Underpinning was a reasonable way of eliminating the nuisance, and second claimant was entitled to recover the costs. And Lord Justice Pill makes it very clear that it is to do with elimination. And interestingly, my submission would be that the £14,000, which was the cost of superstructure repairs, was never actually awarded. If one looks at the bottom box on page 411, it says the cost of the last 3 lines, the cost of remedial work, that was the 14,000. If the tree had been felled, was very small, and its common ground can be ignored for many purposes. And it looks as though the 570,000 was the cost of the underpinning scheme, and the 14,000 was never adjudicated upon, which would be logical, because that 14,000 would surely have been the loss of the previous owners, albeit it obviously faded into insignificance. So, my Lord, I won't go on in this, but there are several references on page 412 and 413 to the fact that this is a claim for the costs of abatement. And with respect to Lord Cook, it's a little, sorry, yes, it was Lord Cook, in the House of Lords, at page 416, his judgment, his speech, is, or does make it a little obscure as to whether this is the cost of abatement or the actual damage, the repair of damage caused to the previous owners. And that's why I took you to the Court of Appeal. But it is clear that this case concerns not compensation for damage, but an award of monies for the costs of abatement to prevent an existent and continuing nuisance from causing damage in the future. Lord Cook, in fact, starts at page 419 at paragraph 3 by identifying the issue on which, as one where there is surprisingly little authority about the recoverability of remedial expenditure incurred after encroachment by tree roots. And he uses that phrase, remedial expenditure, quite regularly, which is where, certainly in practitioner circles, in my experience, it is thought that underpinning is a cost of repair rather than a cost of abatement of a continuing nuisance. And you see at the bottom of page 420, the agents, at letter H, the agents instructed structural engineers to make a report of the cracking in a report delivered to the Church Commissioners in March 1990. They concluded the cracking had been caused by the roots of the tree, recommended that it be removed, that's the tree. If removal was not possible, they recommended underpinning. And then on paragraph 11 on page 422, halfway through the sort of boxed piece, the Court of Appeal held that Flexon could recover on the basis that there was a continuing nuisance. Clearly, Lord Justice Pill, I would submit, was his judgment was accepted. Their reasoning is encapsulated in the following passage in the judgment of Lord Justice Pill, that where there is a continuing nuisance, the owner is entitled to a declaration to abate the nuisance to damages for physical injury and an injunction. So, going back to what my Lord Stevens said before lunch, a mandatory injunction might have been ordered against the Westminster Council to remove the tree because there was a continuing nuisance as a result of that tree. It wasn't, in fact, ever applied for, as far as I know, but I have known in my experience such injunctions being sought and issued rather than incurring the expense. And then, of course, the court has to decide whether damages in lieu of an injunction should be granted in cases where they consider the public interest prohibits, because we all know trees are lovely in London, prohibits the making of an injunction. So, my Lord, the other factor in relation to continuing nuisance is one of limitation. Again, one cannot simply take a continuing nuisance case and apply it across the board, as I respectfully submit the Court of Appeal did in the present case. If you have a continuing nuisance which has been going on for, say, 15 years before the issue of the proceedings, then you can only sue in respect of the damage which has been incurred during the 6 years prior to the issue of proceedings. And in fact, the case which I think my learned friend mentioned, but is not in the bundle, of Dennis and the Ministry of Defence, was one where a householder was complaining about Harrier jump jet noise on their flights. He had been in, he had owned the property since 1984. He didn't issue a writ until 1996, and the learned judge, Mr. Justice Buckley, awarded damages for the noise intrusion at so much per year for the 6 years prior to the issue of proceedings, and in fact for a period from issue of proceedings as well, on an annual basis. That was a case where there was no injunction because of the national interest in keeping Harrier jet pilots well trained, and so the nuisance was, as it were, permitted to continue, and damages were awarded for the period of the continuing nuisance, with a statement that because the evidence was that the Harrier jump jets would cease to be used after 12 years, and so the judgment related to the period up until then, and gave the plaintiff liberty to issue another action for nuisance if the replacement jets were also unreasonably loud. But that's how continuing nuisance works in its different guises.
It's funny, Delaware Mansions is a case that's caused a lot of problems.
Yeah.
And it can't have been regarded, I think, as a terribly important case, because you had on the woolsack Lord Steyne, who wasn't either the senior law lord, who would have been Lord Bingham, or the second senior, who would have been Lord Nichols.
No.
So I suspect people didn't appreciate at the time that it might be a case we'd all end up going back to time and again.
Well, my lord, I think Lord Cook was given a sort of adulatory send-off by...
Exactly. Rather like Lord Gough in that dreadful judgment of his last hurrah was caused a lot of problem. Well,
I hope all your lordships in the lordship will remember on your last judgment. Got to get it right. And be clear. The problem with Lord Cook is he doesn't mention the fact that it is abatement enough, as Lord Justice Pill had quite clear.
Lord Brown Wilkinson was sitting there.
Sorry?
And Lord Brown Wilkinson,
yes,
the name that sort of stands out, but he was, by that stage, he'd retired. He was coming back as a retired...
Yes. So, my lord, just to summarise our position on continuing nuisance, there was no evidence of further encroachment, nor its quantity, and the fact that knotweed had been present for a period of 8 years or more before breach of duty on the part of the defendants means that one really cannot say by mere application of some sort of common sense whether a non-trivial quantity of further rhizomes had transferred from the defendant's land to the claimant's land during the period when a breach of duty was established. Precisely what is non-trivial is itself something of a difficulty, and if there are already rhizomes which have already caused significant damage to the extent that clean-up costs at the very least had to be incurred, what is sufficient by way of further spread onto that land to create the sort of cause of action which Sir Terence Etherton anticipated in Williams, of somehow neutralising this ground, which from our perspective appears to have been already fully neutralised to a sort of zero value.
I thought you accepted that we really don't have the evidence upon which to
exactly
about.
Exactly. So I'm
either in your favour or against you.
Well, luckily I'm only intervening, so I don't have to worry about that. But my submission would be he who alleges must plead and prove. But what the Court of Appeal have done, I respectfully submit, is totally incorrect in applying this concept of damage which occurred from 2013, if that was their conclusion. At least they are applying a breach of duty from 2013 and combining it with a damage which occurred before 2004 and making the defendants liable for it. And in my our written case, we did put forward the forensics suggestion that if in Goldman and Hargrave, your lordships will remember that the fire broke out in the top of a gum tree, I think was 80 metres high or something. And the owner of the land wisely, he couldn't do anything about it up there, but he wisely asked the local fire brigade, I think, or someone, to fell the tree, which they did. Now, suppose that fire had in fact spread before the tree had been felled, there would have been no fault on the part of the individual, and the next door neighbour's land may have been ravaged to greater or lesser extent by flame. But suppose then that after felling, the defendant is at fault, as in fact was, by simply leaving the flames or burning in the felled tree, thinking that that was a safe way of going about it when it wasn't. And the fire then spread, as it did, to his neighbour's land. Is it said that that second fire, insofar as it ravaged exactly the same land, which may have been completely destroyed or it may have been partially destroyed, that the fire which spread due to breach of duty suddenly makes him liable for the damage which occurred without his fault on the day before he felled the tree? And that is clearly, I respectfully submit, a wrong application of the law. My lords, unless there's anything, my ladies, anything I can help with.
Thank you very much, Mr. Parlow. Mr. Carton.
My lady, my lords, my first point really goes to Delaware, and I hope to deal with it quite quickly. And I'm certainly not going to try to discourage you from clarifying Delaware if that's an approach you want to take. But my position is this, which is Delaware really is just a gloss on the decision of Lord Justice Burse, and his decision is correct regardless of Delaware. And in that respect, it's academic, I say, to the issues on this appeal. The one point I make about Delaware, effectively in support of my concession that it's not relevant, is I accept, if nothing else, Delaware deals with a position of post-breach damage with a subsequent change of ownership. And in this case, of course, although the encroachment happened before the claimant purchased his property, that isn't the relevant issue. The relevant issue is that the encroachment happened before the defendant's breach. And so for that reason alone, I accept Delaware is not on point. I will come on to why I say it makes no difference, but it is, I say, simply a gloss that doesn't change the substance of why I say Lord Justice Burse was correct. I come on then as my second point to address how the claim was presented, and that does then inform, I say, the key question on this appeal. Can I take you, please, to page 301, which is from the particulars of claim? And just jumping through some of the paragraphs. Paragraph 3 simply says that the claimant purchased number 10, his property, in or around October 2004. The following page on 302 pleaded in paragraph 6 that knotweed encroached onto the claimant's land from the defendant's land at some time unbeknownst to him. We, of course, later in the chronology have the evidence of Mr. Gregson about when it encroached. But the final point I make on the particulars before I then move on to the defence and will explain why I say this is relevant is page 304.
Oh, I see. And it's helpful to me anyway to have seen in your particulars 1A at the bottom of 302 that soil contaminated with Japanese knotweed is controlled waste. So hence,
it is
a problem disposing of the soil if you develop land.
Yes, and that's part of the rationale in Williams, but it also goes to a question. I think it was my Lord Reed asked. Certainly, it was raised earlier about whether there is a difference between knotweed and other kinds of plants. And one difference is that knotweed is controlled waste, so it needs to be disposed of in a licensed landfill, etc., etc. Otherwise, it's a criminal offence.
Thank you.
I suppose this is a good point also for me to make one comment in passing I was going to make later, which is a recurring theme I appreciate is gaps in the evidence in terms of Japanese knotweed in general and this case. And the one point I wanted to make is there's been reference to the RICS 2022 guidance. Of course, we don't have any expert evidence on that. And I only raise it in passing just to ask that your ladyship and your lordships effectively put it to one side, because it is very much an issue for another case and it can be properly contested with expert evidence. If nothing else, has it made any difference on the existence of diminution in value, etc.? I apologise if I'm stating the obvious.
We all understand this. Thank you. Part of this case.
From the particulars then, going from 302, which has 9.1 at the bottom, on to 304, paragraph 11, the way the claim was pleaded in the particulars was the claimant was contending the defendant came under a duty of care from 2006. Of course, as we know, District Judge Foraker found a duty and a breach from 2013. I raise this for context because if we go to the defence next, please, and page 313, 313, we have paragraphs 15 and 16, which I won't read, but I hope I can fairly paraphrase or describe as being effectively a causation defence. The reason I take you to that then is if I ask you to turn to the reply and you can see what the reply is actually dealing with. If we go to page 319, please. At the bottom, you see paragraph 10 is replying to those paragraphs 15 and 16, the causation defence. And then it immediately goes over the page to 320. And A argued the defendant had constructive knowledge before 2018. Defendant was saying we only had knowledge from then. And B raised the argument, even if knotweed encroached before breach, the defendants failed to carry out reasonable treatment. This has caused the claimant's losses to continue unnecessarily.
Where are you now?
This is the top of 320, my lord.
320.
So it's just followed on paragraph 10, which began at the very bottom of 319.
Yes, thank you.
And then B. So this is really the claimant saying, further alternatively, even if your causation defence is made out, my case is that your failure to treat has caused my losses to continue unnecessarily.
But I'm just going to time to absorb that.
And my position is this on this appeal, and it started as early as the reply to defence, but my position remains this, which is this is not a claim, and it was not pursued at trial. As I say, treatment costs, etc., were conceded. This is not a claim for causing the initial loss. This is a claim for prolonging the period of injury, and in this case, by preventing the claimant from carrying out a remedy.
Well, where do you say that?
Well, it is said in B, in that the failure, so the defendant's failure to carry out reasonable treatment, has caused the claimant's losses to continue unnecessarily. That was then, at trial, the argument run, and the argument run on the two appeals below, was that because the defendant, was in breach, the claimant couldn't treat because it would be futile, because the knotweed would just re-encroach. That was the argument run at trial and on the appeals below.
So his loss wasn't his inability to carry out abatement works.
No,
I'm sorry, I shouldn't interrupt you.
No, I'd plead, my lord.
Develop your argument.
No, to respond. No, his loss was this. His loss was to say, at date of assessing loss, if the defendant had treated from when it should have done, 2013, then the knotweed would have been successfully treated. And I will come on, and I appreciate your ladyship, your lordships will have questions for me about what you can presume and not presume. But that then leads on to the point about you can take, I say the starting point is that the diminution in value will reduce over time. And so by stopping the claimant from treating from 2013 until 2017, it is stopping the clock from ticking and stopping that tapering off process from starting. And so that is what I mean by prolonging the claimant's loss.
But was the claimant even aware of Japanese knotweed or wanting to treat at all in 2013? He was only aware, first of all, in 2017.
Yes, he was only aware in 2017. He wasn't, in terms of intending to treat, he wasn't cross-examined or asked any questions at trial about that at all. And it wasn't suggested that he wasn't asked any questions at all, as I say, about, it wasn't put to him that he didn't actually intend to treat in any event.
I just don't follow. I'm terribly sorry. You submit that the knotweed would have been successfully treated in 2013. That's treated on the claimant's land or treated on the defendant's land?
No, I'll try, if it helps to clarify that. So can I take you please to partly where that comes from, which is page 351, 351. And this is from some Part 35 replies from Mr. Gregson, the joint knotweed expert. And under question 8, it asked, if herbicide treatment is effective, should JKW knotweed be eradicated within 4 to 5 years? He says it's not eradicated.
351.
Sorry, my lord.
Are you on page 351?
Yes, 351 is question 8. It doesn't have a question mark after the question. It ends in a full stop, but it's question 8. If herbicide treatment is effective, should JKW be eradicated within 4 to 5 years? Does your lordship have that?
Yes, thank
you. Thank you. It's really the second paragraph of the answer, which is if a stand of knotweed is properly treated with a glyphosate-based herbicide at the correct time, I would expect all above ground growth to have ceased after 5 years. So I take from that, once you start treating, if it's done properly, the treatment will have run its course effectively after 5 years.
Above ground. Underground, the rhizomes will remain.
Yes.
And whereabouts is this treatment taking place?
Well, that it would logically have to be on the claimant's and the defendant's land, because it is a contiguous stand of knotweed. But it matters not for these purposes. Any stand of knotweed, what Mr. Gregson is saying is, if it's treated effectively with herbicide, you would expect the above ground growth to stop for the treatment to be effective within 5 years.
So the breach of duty of the defendant is not to inform the claimant of the fact that there is a need to treat not only his own land, but also the claimant's land. The claimant doesn't know anything about the knotweed until 2017.
No.
And so the only way you can get the treatment is if the defendant has an obligation to tell the claimant.
Yes, well, that follows, I would say, from the defendant's obligation is to carry out reasonable treatment. It follows, if it's a necessary component of reasonable treatment, that you tell your neighbour so they can treat as well. So I would say that simply follows from the general obligation that would be on a defendant to carry out, to comply with its duty as a reasonable landowner.
That's a duty of care and negligence, isn't it?
It is, and I know we're going slightly off piece, my lord, but that, because of course that isn't an issue.
I'm not going off piece.
It's the appeal focuses purely on causation. My point is that the building block is the 5 years for Mr. Gregson to treat. Therefore, if the defendant is in breach, as was found to be the case from 2013 to 2017, that 5 year period to effectively treat cannot start. And so a claimant comes to trial in a position of, had the defendant not been in breach, that 5 years could already be over, or a significant portion could be over. My loss would be less. I'll come on to the tapering point in a second. But in fact, it's not, because it still remains at its apex, because it hasn't yet started to decrease. So that's the basis of the argument.
Sure.
And on that point about the tapering off, I say it has to follow. I appreciate there's no evidence either way on the question of the period of time, etc., that it will taper off. I say it has to follow, just applying a basic principle of the inherent probabilities, that there will be a tapering off. And I say in the absence of something to explain why that is not the case, then surely I say the most likely explanation must be the default.
And what follows from the basic principles of probabilities as to the shape of the graph of the tapering off?
Well, that's where, my lord, I say it was incumbent on the defendant to challenge that. And in that respect, Lord Justice Burse agreed. And my lord, apologies, I'm just getting up my note of the reference with the...
Sin.
$53.
No, thank you, my lady. It's not. It's 170.
Yes.
It's paragraph 53. Quite right. Thank you. Yes, page 100. This was in respect, we can see for 170, my lord, and paragraph 53. This was in respect of a ground in the respondent's notice, defendant's respondent's notice, which isn't pursued on this appeal, which was about the quality of Mr. Rain's evidence. And it's the third point that Lord Justice Burse made in that respect. If, as the respondent, the defendant contended was the claimant's case, the degree of residual diminution in value would itself reduce. The sum should also be reduced. And then we can see later in the paragraph, if the respondent wanted to advance this as a basis for materially reducing the figure claimed, it was incumbent on the defendant to provide that evidence at trial. There is none.
What's the legal authority for that proposition?
The legal authority, I say, the most recent is the Armstead case, from the 14th, and I've handed up five printed copies over.
But this reads as though the argument was the other way around. If you, in that paragraph, if you go to line 5, this third submission being made by the respondent, the respondent submitted there were 3 flaws in the evidence. So this is the argument. The respondent at this stage was Bridgend Council.
Yes.
So this is their argument. And the third flaw in line 5 is if, as the respondent contended was the appellant's case, this is the respondent's contention, the degree of residual diminution in value would reduce over time, then the damages should be reduced. And that contention by the respondent is being rejected in the 5th line from the foot, or 5th and 6th lines, because there's no evidence about timescale. If the respondent wanted to advance this, it's incumbent on them to provide that evidence at trial. So, I mean, it's the point, I mean, as Mr. Palmer said, the usual rule is for the person who's affirming a proposition to produce the evidence in support of it.
Yes. That's where we come on to the Armstead case, but I'll take your ladyship and your lordship to it in a second. But my point on it is this, or on the position is this, which is the claimant's case as run at trial and successful was the defendant's breach has prevented me from treating, has prolonged my period of loss, and it has caused me loss because I am now earlier on in the tapering profile. Whether the tapering profile is a straight line, a circle, doesn't matter. I'm earlier on in the tapering profile, and so my damages at time of assessment are higher than they would have been but for the defendant's breach.
Well, doesn't the objection that Lord Justice Burse made to the argument be when it was advanced by Mr. White, doesn't it stand equally as an objection to your argument that the problem with your submission is there's no evidence about timescale? If you wanted to advance this as a basis for materially reducing the figure claimed, or indeed in your case for supporting the figure claimed, it was incumbent on you to produce that evidence at trial.
Well, if I take your lordship, please, then to the Armstead case at this point, and paragraph 58 in the judgment of my Lord Borough's and Lord Legate's joint judgment, that there was under the heading of the burden of proof.
Sorry, but which paragraph?
Paragraph 58, my lord.
Thank you.
It's page 17, I think, of the judgment. Now, that obviously sets the framework because it's under the heading of the burden of proof, talks there about the consequences of the concession, who's treated as having the legal burden of proof. Really, paragraph 63...
What about paragraph 59? The correct analysis is that once the claimant has proved that a tort has been committed,
yes,
and that the loss claimed was in fact caused by the defendant's breach of duty.
Yes.
Mr. White would say that you have not proved the loss claimed was in fact caused by this client's breach of duty.
Yes, I understand that. I say that the claimant has. I take the point. The point, as I understand, Armstead deals with stage 2, which is once you've already proved causation, then what does the defendant need to plead and prove? But the way the case was run, as I've addressed...
Yeah, but I mean, the authority you're taking us to, and I've never looked at it until now, but it looks as though it's dealing with what are proved to have been losses actually caused.
Yes.
It's concerned with the question whether they're legally recoverable,
yes,
in the light of the principles of remoteness.
Yes. But in this case, I say the claimant can prove that the losses were caused because the claim, as I've tried to convey, the way the claim was run and succeeded at trial and on the appeals below, was that this is a case of the claimant has been caused additional loss because they are earlier on in the tapering off period than they would have been but for the defendant's breach. At that point, the question is, what is the quantification of that? And at that point, Lord Justice Burse's judgment in paragraph 53, I say, was correct and was consistent with the approach in Armstead, which is we are beyond stage one and we are now into the point of it is for a defendant, I say, to raise with evidence what the loss would be. Otherwise, the consequence, as in Armstead at paragraph 63, is that otherwise the wrongdoer bears the burden because the onus is on the wrongdoer to show a good reason why the wrongdoer should not be liable to compensate the victim for the full extent.
But the difference is that this case is concerned with issues of remoteness that arise after the factual consequences of the breach of duty have been proved. Right?
Yeah.
So it's dealing with things like novus actus and
Yes.
Mitigation, contributory negligence, and so forth, and saying, well, the onus is on the defendant to establish factors like that cut back the recovery of what are established to have been the factual results of the breach of duty.
I understand that, and I don't disagree, my lord. Let me try and set out then the building blocks for why I say that initial causation is actually established. The first...
So I think we can put Armstead to one side because I don't think it supports your case.
I would say it does if we get to the second stage, but obviously the crucial bit I accept is showing causation in the first place. Yeah. And I will address your lordships on why I say the claimant can show causation. The first is, as I say, given the nature of the claim, which is that the defendant has stopped the claimant from being able to treat and to abate effectively, then he has suffered.
Where do we see that as the nature of the claim? But the claim is based on the defendant preventing the claimant from carrying out abatement works. I haven't so far seen that as being the basis of a claim.
Oh, my lord, can I take you please to 185? And it's paragraph 27 at the very bottom that then goes spelt over the page. And it on 186 over the page.
Yeah.
On the it is claimed the defendant's delay in starting treatment. Now, I'll come back to, because I know my learned friend Mr. White said that it's simply recording what the claimant argued. But that for a start, that demonstrates that was how the claim was pursued at trial. It was pursued in exactly this way of saying the claimant wasn't able to treat because the defendant wasn't treating, and therefore it was futile for the claimant to attempt to treat the knotweed on his own land.
I mean, still struggle to see how the claimant was going to treat anything.
Well, my lord, on that, again, the claimant wasn't challenged. It wasn't put to him. It wasn't argued as a failure to mitigate, for example, that he just wasn't bothered and was never going to treat. And it is a failure to mitigate argument, I say. And at that point, it is very much the case that it was incumbent on the defendant to raise it, and it wasn't put to the claimant.
I don't think there's any suggestion that your client failed to mitigate his loss.
No, but I'm saying that argument, that would be a failure. I agree. That's my point. It wasn't pursued and the claimant wasn't cross-examined on it. But I say it can't, on this appeal now, the findings of fact from the trial judge, based on the questions that the claimant was asked and the evidence that the judge heard, it was not a live issue. The claimant was not asked whether he would have in fact treated or not.
have to ask him. He didn't know anything about it, therefore he wouldn't treat it.
No, well, again, my answer to that is from your lordship's question previously about the duty to notify, and I say it follows as a logical component of the defendant's duty to treat that they ought to tell their landowner, because otherwise it doesn't make any sense. And so if the claimant didn't know about it, that was through the fault of the defendant during 2013 onwards. That would be my answer to that, my lord. But
I mean, I'm just having some difficulty pinning down what precisely your breach of duty now is. My understanding is that we're dealing with a case where the breach of duty is constituted by Japanese knotweed encroaching from the defendant's land onto the claimant's land and affecting the use and enjoyment of that.
yes,
That is the breach of duty that I, with knowledge, constructive or actual, have allowed, if you like, that Japanese knotweed to encroach. Now, as I understand it, you're now superimposing almost a separate duty, as I understand it, which is that the defendant has prevented the claimant from treating Japanese knotweed on its own land. Your breach of duty has now become something somewhat different, as I understand it.
It's not superimposing an additional duty. It's looking at what the causative effects of the defendant's breach were. And a causative effect of the defendant's breach was the claimant couldn't treat. It's just a causative effect of the defendant's breach.
And it wasn't a causative effect if he didn't know anything about the presence of the Japanese knotweed in the first place.
Yeah, but that comes back, my lord, to the point I've made, which I would repeat, which is, of course, the defendant being in breach from 2013 to 2017, the only way to reasonably treat would be also to inform the claimant as the neighbour. Otherwise, the defendant's own treatment
Well, it would defeat. This takes us back to my lord's point. You seem to be running an argument now that the breach of duty is a failure to inform the claimant of the presence of Japanese knotweed, with the consequence that which caused the claimant's failure to eradicate the knotweed on his own land.
My case is that the defendant's breach from 2013 onwards had the effect of preventing the claimant from treating his own land. And that is my argument, my lord. And in respect of that, can I take your lordships, please, to page 169?
Have we got any other authorities that have this sort of added, if you like, spin on what the duty actually is? I mean, we don't, when we're looking at Delaware, just to take one case, we just start thinking about, well, has there been a breach in stopping you baiting the nuisance in some way, do we?
Well, I say it really is the analogy I've given in my written case. I say remains good, which is it genuinely is as simple as somebody breaks I'm at work, I break my leg through no fault of anybody's. My employer stops me going to hospital negligently. I can't claim the initial breaking of my leg, but I can claim any additional damages, or the damages for the additional period of suffering before I'm able to go to the hospital against my employer. This is the same. This is analogous, I say, in that the breaking of the leg is the encroachment of the knotweed. The damages is, for one, the cost of treatment, which, as I say, I conceded at trial because it's a binary cost and it fails the but-for test. But this is akin to the claim for the period of avoidable additional suffering.
And if your argument about avoidable additional suffering doesn't hold up,
Yes.
do you accept that the diminution in value occurred prior to 2013?
Yes, I do. On the facts as the trial judge found that the knotweed encroached in 2004.
Yeah.
Certainly by the time of defendant's breach in 2013, yes, I take no issue with that. My case is a narrow one in that I very much am pinning my colours to the mast of this argument. I say the analogy of the avoidable period of suffering. I'm not running any other argument on top of that. So if your ladyship and lordships are with me on it, great. And if you're against me, I accept, then clearly my client loses. I'm not running any additional arguments.
So I must say, for my own purposes, that when you use that analogy in your submissions, I actually was struggling to understand what you meant. I actually couldn't see at that stage, but I think I understand what you're saying. I mean, my query is whether it's embraced by our normal understanding of the tort of nuisance, that is a breach of duty, as you're now positing it, for it is actually almost negligently delaying somebody carrying out treatment. And I ask myself, are we in the tort of nuisance at all?
Well,
or is this a sort of new duty of care in the tort of negligence?
Yes. I mean, it's rather like in Sandy Denfield, approaching the case on the basis that the defendants ought to have informed the plaintiff so that the plaintiff could have constructed flood defences. Yes, rather than simply having a claim in nuisance for the flooding that occurred through for allowing the blocked pipe to remain on the land.
Well, my lord, one point I don't think will be controversial. I'd have to take a minute to actually dig up the references. I know it's said in Delaware as well as other cases, but there is plenty of reference to, in many respects, that the tort of nuisance, the tort of negligence are labels of no real significance. I think it is Delaware Mansions. The real question is reasonable foreseeability and reasonableness between neighbours. I'm not saying there are no differences, but this falls under the umbrella. In response to my Lord Laura Borough's question about are we dealing with nuisance or negligence, this would fall under the umbrella. Well, it doesn't actually matter for this particular question. They're just labels in that respect. And the broken leg analogy, as I say, my argument doesn't go to the question of breach of duty. As I say, in my analogy with the employer, I'm not getting into arguments about on what basis are they negligently stopping them going to hospital. It's just an example. In the same way, this case, it is purely a question of the causative effect of the defendant's breach. And the defendant's breach was as simple as failing to treat from 2013 until 2017.
The passage you referred to is page 428.
Thank you.
Of 31.
Thank you, my lord.
Delaware.
The essence of what you're saying is that what the defendant's at fault for is the delaying in the treatment of by the claimant of the knotweed on his own land.
Yes. And
But the delay in treatment on the defendant's own land, isn't it?
It's both. The defendant's breach is failing to control the knotweed on its own land, yes. But the causative, I'm sorry if I answered that badly, the causative effect of that, or one of them, is also that the claimant cannot treat his own land.
Right.
And that is something that, for instance, I say Lord Justice Burse accepted, and I say was right to accept. And my lady, my lords, we can see that from his judgment on page 169, paragraph 48. Where he talks about the attractive simplicity of defendant's point on causation. But the crucial part there, starting from line 3, about the knotweed was still encroaching on the claimant's land, and any treatment by the claimant would have been futile unless and until the defendant complied with its duty. So that's my point.
And that addresses treatment as opposed to diminution in value. You've named yes of loss, diminution in value, and the diminution in value occurred as you accepted occurred.
It does.
Prior to
Or it did. Yes, but my lord, the treatment, my argument is predicated on what I've said is I say the only reasonable logical starting point, which is absent evidence to the contrary, it is likely that diminution value will reduce to whatever extent over time, because it's hard to see why it wouldn't, absent some evidence otherwise. And so treatment, the use of the word treatment there, treatment by the claimant, once the claimant treats, Mr. Gregson says 5 years, his diminution will then begin to taper off. And so that is, these are all points why I say a causative effect rather than a breach itself. A causative effect of the defendant's breach is to cause the claimant additional loss because it holds him back earlier on in the tapering off profile.
But if you just look at the last sentence of paragraph 48, the harm then has been caused by the breach of duty. But you accept that the harm, that is the diminution in value, was caused prior to the breach of duty.
Well, the presence of the diminution in value was caused, yes, by the encroachment. Certainly, it was caused before the defendant was under duty. But the harm, I say that Lord Justice Burse is talking about, and certainly I am talking about, is this prolonging of the diminution by preventing the tapering off period from starting. That is the harm I'm talking about. And that harm has been caused by the defendant's breach of duty, because had the defendant treated in 2013 or some point before 2017, I say logically the claimant would have been in a different position. And once the claimant shows that, I say Lord Justice Burse was correct when he said that it was incumbent on the defendant to raise some challenge to quantum if it wanted to reduce the amount of recoverable quantum. And had the defendant done so, I fully accept if the evidence said it would be whatever percentage, that would be what would be recoverable. But there was no evidence on that.
Your arguments, look, if I can use your analogy against you, you use the analogy of the person with the broken leg and there's a culpable delay in getting him to hospital. And as a result, he suffers additional pain. You're effectively claiming for the entire pain caused by the broken leg and saying that it's for the defendant to establish what the additional element was caused by the delay in treatment.
As I say, had it been raised, had the defendant raised it in evidence, as I've said, I would accept that it would have to follow as a consequence that the damages would be whatever percentage, let's say for argument's sake. But the fact is, it wasn't raised. I'd say Lord Justice Burse was correct to say it should have been raised. It was incumbent on the defendant. And we are in the territory, the Armstead case at 63, where it talks there about the wrongdoer, the onus is on the wrongdoer, and otherwise the wrongdoer will be liable to compensate for the full extent of loss.
Did you accept that in your examples it would be for the claimant to establish what the additional pain or suffering was attributable to the delay?
I don't, my lord, or at least I put it differently because...
So do you say the claimant is entitled to be awarded damages for the broken leg unless the defendant establishes what the additional suffering was attributable to the delay?
I say at this point, the analogy isn't helpful in this respect, because part of my case is, as I say, predicated on the inherent probability that diminution in value will reduce over time. In the case of the broken leg, I think dealing with it in the abstract simply becomes unworkable. But in terms of how would the claimant approach it, or what damages would the claimant be entitled to, if the defendant failed to address in evidence, then yes, the claimant would be entitled.
Right.
My lady, my lords, unless you have, and I appreciate we can come back at the end, unless you have any questions on that point, I propose to move on to Jalla and my comments on Jalla.
Certainly.
My first point on Jalla is I say it doesn't arise in this case, in that it is ultimately a limitation issue. Limitation wasn't pleaded in this case. It's not been a live issue. If your ladyship and your lordships do consider Jalla, my second point is the obvious difficulty that's been raised, which is the lack of expert evidence about the mechanics of encroachment of knotweed, etc. And it's difficult to argue that in a vacuum. It ought to be.
Are you now addressing the question of the continuing nuisance?
I am. So when I say Jalla, that's my shorthand, yes, for the continuing nuisance, my lord, yes. So as I say, my first point is really limitation, not on point. Second point is it ought to be something that's properly ventilated at a trial, etc., with expert evidence. If for whatever reason your ladyship and your lordships are against me on that, then I'll just briefly deal with Jalla. On the information we have, absent detailed expert evidence, I say there is no reason why a Japanese knotweed case is not a continuing nuisance for the purposes of Jalla. And in that respect, I say the crucial paragraph of Jalla is paragraph 30, which is at page 625. And that's the paragraph, of course, that refers to Delaware Mansion's case about tree roots and says it's a good example of a continuing nuisance, need not be a paradigm example. The crucial part is about the ongoing state of affairs outside the claimant's land. Again, a Japanese knotweed case, certainly on the evidence we have before us, I say falls squarely within that. You have a standard knotweed on the defendant's land, not being treated for as long as the defendant's in breach. That is an ongoing state of affairs, and it is a continuing nuisance within the meaning of Jalla. And I don't propose to say anything more than that, simply because, as I say, my second point was it's difficult really to say more without proper expert evidence and having the arguments ventilated. My lady and my lords, that then deals with my submissions on Jalla. I've addressed you on how I say the claim was presented and why I say the Court of Appeal was correct. Unless you have any questions for me, those are my submissions.
Thank you very much, Mr. Carter. Yes, Mr. White. My lords, I anticipate needing not less than 15 minutes and not more than 30. Yes? Are you content for me to press on into?
Oh, yes, by all means.
Thank you. Would you excuse me for a moment while I turn behind and pick up a lectern?
Yes, certainly. Thank you. I want to borrow this one. Yes.
I begin with the observation that we are all tiptoeing around the problem that this is the final court, and anything that is said by this court is seized upon in all future cases and rightly, insofar as it is ratio, treated as determinative, and wrongly but nonetheless so, insofar as it is obiter, treated as determinative or at least significant. I agree with the proposition that arose in argument that this court should not be attempting to give any definitive guidance in relation to Japanese knotweed cases on the basis of the evidence that is before this court. Rather, what is at the heart of the matter here in my submission is two things. Firstly, the Court of Appeal have just made a mistake in the way that they interpreted Delaware Mansions, and so this court needs to fix that. Secondly, it's the question of causation, which is the point in issue here. And so I find myself allied with Mr. Carter in saying this is not the case in which to make determinations on whether knotweed is a continuing nuisance in all circumstances or not. That the practical reality, I suspect, is that sometimes knotweed will be a continuing nuisance and sometimes it won't. But this is not the time to deal with. I cautioned you earlier about the change from RICS 2012 to 2022, and I explained RICS categories 1 to 4 on the basis of my best recollection and said that I would check that I'd got it right. I've checked, and I'm pleased to say that I did get it right, and even more pleased to say that you can see those RICS categories without going beyond the bundle, because they are within Mr. Gregson's evidence on page 339. But to remind you, those 4 RICS categories have now been withdrawn. But again, I find myself singing from the same hymn sheet as Mr. Carter. This is not the time to determine what knotweed nuisance looks like in the modern RICS 2020 world. It is simply a time to observe that things have changed. For the sake of your note, the research, which is the reason why things have changed, is summarised on page 808. So that is Mr. Gregson summarising research from Dr. Mark Fennell. I need to deal with what was said at paragraph 50.
Sorry, what page reference did he give us for that?
808. It's in the supplementary.
Supplementary, sorry. Yes, thank you.
Our supplemental, well, I've got that, yes.
I supplemental bundle and got 12 pages.
Only has 12 pages.
Yes, it was numbered sequentially to follow on from the main bundle.
It's Appendix 4. Yeah.
So that's right, it's Mr. Gregson's Appendix 4, and at paragraph 8 to paragraph 14, he deals with the research, the key findings of which are paragraph 12. Knotweed causes very little, if any, damage to structures. Other plants are much more damaging. Rhizome spread is typically 2 metres, rarely more than 4. And there's no scientific justification for restricting mortgages due to the plant being within 7 metres of the building. You'll remember 7 metres was the magic number so far as the Royal Institute were concerned in 2012. I need to deal with what is said in paragraph 53 of the Court of Appeal's decision. 53 on page 170. So this paragraph is used to support the proposition that the burden of proof rests on the defendant to show the taper that is alleged to exist in relation to residual diminution. And it is the respondent's third argument as has been identified. And the third point is the respondent, picking up from the words third if, as the respondent contended was the appellant's case, that is just pausing there, that's me saying what the claimant is arguing here is that there's a taper. And going on to say, if that's right, then the passage of time means that we're some way down the taper. And the court needs to address that. And the court appears to have been in some doubt as to whether or not that was in fact the claimant's case, in the way that it said that that was the respondent's contention as to the claimant's case, and has then said, well, if the respondent wants to show where we are on the taper as a basis for reducing the figure, then they have got to show where we are on the taper. But the Court of Appeal did not, and Mr. Carter has not overcome, in my submission, the most basic part of this. I agree with what was said by Mr. Palmer, that he who asserts must prove. The claimant asserts that he has suffered loss as a result of 5 years, meaning that we are somewhere else on this mysterious taper of which we've got no evidence. Well, the claimant's got to prove it. I suspect that this argument on the part of the claimant failed, if it hadn't already done so, in the moment when Mr. Carter was forced to accept that if the defendant didn't prove what pain the negligent delay in taking the man with the broken leg to hospital caused, the defendant then had to pay for the fact that the leg was broken in the first place. Rather, the reality is a claimant must prove what the breach caused, the claimant must prove what pain the delay caused, and there's never any question that unless the defendant shows what the delay caused, the defendant must pay for the broken leg.
It might be a little bit more fundamental that he who asserts must plead and prove a case.
You are right to correct me.
No, I'm not. I wasn't seeking to correct you at all. I was just commenting, I suppose.
Well, if I may, I'm going to use the comment as a springboard for my next point by way of response, which is this. There was a suggestion during Mr. Carter's submission that the failure on the part of the defendant encompassed a failure to notify the claimant in 2013 that he needed to start treating knotweed on his own land. There are two primary problems with that allegation. First is that it is no part of the claimant's pleaded case. Rather, what is alleged in the particulars of claim, and you find the allegations on pages 304 and 305, is a failure to treat the knotweed, and effectively that must be failing to treat the knotweed on its own land. There's no allegation that the defendant should also have notified the claimant. And why not? Well, there's the second fundamental problem. Our law allows us to be bystanders as a matter of generality. We are not required to dive into the ponds to save someone who we see in trouble. there is no legal obligation, whether one dresses it up as negligence or nuisance, on behalf of the defendant to say to the claimant, you've got a problem there, you need to do something about it. So had the allegation been made, it would have been defeated on that simple basis. I offer no authority for the proposition, simply because it's something that's come up for the first time during oral submissions in the Supreme Court. It's the sort of allegation that, if it was going to be well-founded, needed to be front and centre from the commencement of the case. I'll just take a moment to check my notes to see if there's anything else that I need to do with. The only thing about things to use by way of response is to address you briefly on Armstead, now that I understand the way that the case is used. Can I take you, please, to one paragraph that has not been looked at yet within Armstead, which is paragraph 23. What is said there by Lords Levis and Burrows is, where it is shown that loss has factually been caused by the defendant's breach of duty of care, 5 principles are capable of limiting the damages recoverable by the claimant: scope of duty, remoteness, intervening cause, failure to mitigate, and contrive. It is against that background that we get to paragraph 59, to which you were referred earlier. In fact, it might well have been Lord Reid who particularly mentioned paragraph 59. The view of the court that the correct analysis is that the claimant has to prove a tort's been committed and that the loss claimed was in fact caused by the defendant's breach. Then the burden switches in relation to those 5 potential methods of limiting the liability in paragraph 23. I do not contend that any of those 5 methods of limiting the liability in paragraph 23 apply here. Rather, I contend that we never get to those issues because the claimant has to prove what loss was in fact caused by the breach. And where the breach is a period of 5 years delay, the claimant has to prove what loss is caused by the period of 5 years delay, and cannot simply say, well, there was some breach and there was some loss, ergo all of the loss is attributable to the breach, unless you prove otherwise, when we know that that is not right. That is, we know that the loss was not all caused by the breach, and where the law imposes the burden of proof in those circumstances is on the claimant. My lords, my lady, if I can assist with anything else, I will. Otherwise, I can conclude there. Thank you very much, Mr. White. Thank you. Well, we're most grateful to all counsel for their submissions. We'll consider the submissions and let you have our judgment in due course. And we will take to heart the warnings about not trying our comprehensive guide to the law, not we in this case. Court will adjourn.